Hi, welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, here with my son and content genius, Michael Rivers, who is behind the camera and actually behind the content. And today he thinks it's really fucking funny for me to react to lawyers getting their ass kicked in court. And not by the judge, not by the prosecutor, but by their clients. Attacks, and this does happen, but I've never had it happen. You know why? Because I'm a badass mother. No, I'm not really. So this might be kind of comical, and I might have things to say. But before we get to that, I just want to give you an update on my grandma. You know, remember I told you in the last episode she was on the run? Sad to say that grandma got picked up by the cops. Now, we had to go to court, and her lawyer withdrew, so I had to get another lawyer for her. And now she's got a RICO conspiracy. She thinks she's some kind of elderly gang member, and I really don't know what the hell is going on with her. So we got her a new lawyer, and the new lawyer wanted a retainer, which I paid graciously, and but I couldn't get to see him because I was in trial. And so what do? We e-signed the document, and he sent it over via email, and so it's e-signed. And I guess all he had to do was just download the app. He got 3 free signatures a month. And so I e-signed it, because if it's not e-signed, no one signs. It was a very effective way to get my grandma a new lawyer, but I'm not bailing her out this time. She's in custody, and she's just going to have to stay there, at least until her, her RICO charges are adequately addressed. eSign.com, a very effective way to remotely do business. I do it all the time whenever I have a client who needs a retainer agreement and they can't come into the office for whatever reason. It's super effective and fast, but you can do it for any kind of document. eSign.com. And we love eSign.com. We do. All right. So when you're in court, and let's say you got, and let me just tell you this. I don't like all my clients. What? We can't always pick our clients. Sometimes we can. Sometimes we can't. In my last trial, I think I told you in our last episode that I had a trial this week. And, oh, my God, it was amazing. And, when you really like your client, it's easy to advocate for them. When you don't like your client, sometimes it's a little more challenging. Doesn't mean you lay up. Doesn't mean, you ever seen Cape Fear? Cape Fear is a hell of a movie. I recommend it, whether it's the old one with Robert Mitchum or with Robert De Niro. Both of them are fantastic movies. And I've never had a client that creepy, but I highly recommend that movie if you're into lawyer stuff. So let's kind of get to it. This is a Florida killer. Robert Zeller is accused of the 1990 murders of an 11-year-old boy and a family friend in Florida. Everything shitty happens in Florida, right? And we'll watch this, and we'll see what happens.
What's that?
Now he says, "Can I speak with you?" Now, mind you, he's about to be sentenced to death. He really fucking nails him there. Did you see that? Right in the mouth. Now, remember what I think I told this story a while back. I'm sitting there waiting for a verdict and on a murder 2 case. And my client was in custody. And he's sitting at counsel table with me. And he looks at me and he says, "If it's guilty, I'm jumping across this table. And I'm going to whoop that prosecutor's ass." And I'm thinking, well, the prosecutor was a real prick to him. He was a real prick to me. This guy had the biggest forearms of anybody I've seen. And we get the verdict, and it's not guilty. So it's an acquittal. And but those I figured, if he was going to jump across the table and take a swing at him, he'd probably get 1, maybe 2. But the deputies would have been on him probably even before he got to him.
All right. I ain't doing nothing. Relax. I'm calm.
Shirley, are you okay? I'm fine.
I am relaxed. I'm calm. Relax.
I used to box. I've taken a lot better shots than that.
I used to box. I've taken it. Here's the other thing. I really like to joke around a lot in the courtroom. You got to be careful when you do it. You can't do it, when it's, a very serious matter going on. But, when you take a shot like that, that's the right response.
What's that?
Let's watch this again. He wants to talk to his lawyer. Come on over here. And just watch his elbow. Wham! Right in the fucking mouth. Oh my God, that looks just awful. He really socked him good, and he in handcuffs, mind you.
We left.
I used to box. I've taken a lot better shots than.
All right, let's. Are you liking this? Let's look at another one. Somehow Michael thought this would be really fun to watch a lawyer get punched by his client. So this one, Taylor Shabusiness. Taylor Shabusiness. Is that her name? Her name's Taylor Shabusiness. 25, attacked her attorney Tuesday during a court hearing moments after the judge agreed to delay her trial. You know, you're sitting there in an orange jumpsuit. You're eating shitty food. You don't really ever get regular shoes. You don't really get to wash and shower or do anything you want to do. So and when you're languishing in court and your lawyer comes and says, "Well, we're going to get a new trial date," and you think you're almost up to your trial date, it's a little frustrating for some of these folks. Another satisfied customer. What the fuck? And her sandals fell off. Her county issued sandals fell right off. You know, I secretly think the deputies kind of like, you know, to get called into action, unless it's some big motherfucker that really is, you know, can handle some of these guys. But a little gal like this is no match for these deputies, especially one that's had too many lunches.
Rachel, call.
Now this is kind of interesting. She's basically straddling him, and you know, does he have to report this to his wife? You know, that's just a fit of rage. You know, I mean, how did that help her? It didn't help her at all. I had a homicide case. You know, Michael actually did some legal work on the case. He actually got the guy out on compassionate release early. And then what did he do? He went in home and he slashed his wife up. And so, but while this is pending, while he's sitting in court, what does he try to do? He tries to escape from jail. And what does he try to do when he escapes from jail? He takes a pencil, holds the guard like this, and holds it up to his throat saying, "Let me out, let me out." And that was all on video. So when we had the trial, they put a brace on his knee. Because, you know, when you're in trial, you have to be in street clothes. They don't let you try a case with you know, your prison fatigues. So they put this brace on his knee so he couldn't run away.
You went off on your attorney, Taylor. You went crazy on
What happened? What happened? I don't know what happened.
your attorney.
Yeah, it was certainly an attack, and I've been in so many courtrooms and so many cases, and this is the first time I've really seen a defendant physically go after their own attorney.
All right, here's another one. This is a court cam. Man attacks attorney, complains about his mugshot. You know, if you're sitting in jail, I think the quality of your glamour shot probably is not your biggest concern.
We head to Seattle, Washington, and the King County Courtroom.
This is State of Washington versus Chris.
First of all, it looks like Ted Kaczynski. It looks like he's been in the woods way too long and probably doesn't smell good.
Christopher Teal, cause number 1810.
Second of all, the lawyer should really have his eyes. You know, you can't have your eyes everywhere, you know. So the court clerk is calling the case, and it looks like they're about to release him from his handcuffs.
First-degree rape and unlawful imprisonment. Teal allegedly followed a woman into the bathroom of a car dealership, locked the door, and raped her.
You know, I'm going to just come out on a limb and say I'm against this kind of conduct. These guys who do this kind of stuff, it's violent, and generally bail for these guys is super high. So that's why they're usually in custody.
The defendant's in court for a competency hearing to determine.
So competency means whether or not they can stand trial. And I've got a client right now two clients actually, who were declared incompetent. One's on a homicide, one's on a gun case. And if they're not competent, they can't proceed forward.
Determine whether he's fit to stand trial. Standing next to him is Reed Birkland, his court-appointed attorney.
And the thing is, you're standing there next to your client. You have no fucking clue that anything's up. You certainly aren't expecting any kind of assault.
He's in custody. He's represented by counsel, Mr. Berkland. Mr.
He raises his arm toward Berkland.
To in a moment.
Without provocation,
So he just slams his fucking lawyer. Jesus. Did you hear that?
Teal
So that's an assault 5, misdemeanor assault. And it's also contempt of court because it's conduct that happens right in front of the judge. So it could be considered criminal contempt, and if it's criminal contempt, she can give him additional jail time right then and there.
an attorney.
Face down! Face down! Put your hand up!
Every courtroom's got multiple deputies. Usually there's, multiple deputies.
The guards immediately pounce on the
And this guy's a skinny little guy.
6'3" defendant and take him
Oh, he's 6'3". My bad. But he's skinny.
to the ground. Teal's attorney looks to be unhurt.
Put your hand behind your back.
He's not hurt. He just got a little slap and tickle.
And even then, he refuses to go quietly.
Bring the chair. Bring the chair.
Bring the chair. You know what the chair is? The chair is they lock your hands and your feet down and probably put a hood over you. The spit hood.
A spit hood is placed over his head.
What did I say?
As officers were
Okay, now I haven't seen this, but I have been around, so I can predict how these things are going to go.
turn him to jail. Berkland chooses not to press charges, but he does remove himself from the case.
I'd remove. You'd have to remove my foot from the guy's ass. I mean,
Nearly 2 weeks later, Teal returns to the courtroom.
In a chair. Fucking.
His biggest concern is how his hair looked in his mugshot.
I'd like to know where the they got that photo of me with my short hair. Because that was on Facebook, and I don't have a Facebook.
Think he's competent?
Like, do they have access to Google?
There's competence. I had one client one time in drug court stand up and yell. He apologizes to America. He apologizes to the nation of Colombia. He's the son of God, Pablo Escobar, and then he's putting a bounty on everybody's head, and then they took him away, obviously. Okay, so this next one is, another competency kind of thing, and the lawyer says, well, he might explode.
On record 03CR0288, Commonwealth versus Percy Allen Phillips.
See, you get. The court doesn't have any clue as to what your client is and what they're about. And then when they get in the courtroom, it's up to you to kind of figure out and navigate the area. And if there's an issue, you're supposed to tell them.
Jay Lambert on behalf of Mr. Phillips, Your Honor. He's present and seated next to me.
Your Honor, Bruce Rivers on behalf of the defendant who's seated next to me and is about to kick my ass.
Phillips is accused of retaliating against a witness inside the courtroom during a previous trial.
Well, that worked so well. Well, why not fuck up with your lawyer?
If we end up in trial, there is no way I can competently even frame a defense.
That just sounds like it's another way of saying, Your Honor, I am completely fucked here.
What do you want me to say or do at your trial? And he won't tell me. He literally, for years, has not said a word.
I think he's bubbling up on the surface.
Mr. Phillips has shared that.
Look at the deputy behind him. He's saying that he's about to say that his client's going to blow. But look at the deputy. Does the deputy look like he's ready to spring into action? He's sitting on his hands, basically.
He doesn't know exactly what he'll do in certain situations in the courtroom. He thinks he just may explode.
Now it's over to the...
That's called foreshadowing.
The police officer who testified against him.
See how they get an old guy there. And the old guy was sitting on his hands. Basically, we call that ROD, retired on duty. What's that sound? It's not a machine gun. He's getting tased. And the judge is secretly enjoying that.
They were 16 to 239. I had to stun Percy Phillips. You want to come on up?
He thinks he just may explode.
I think it's just the word explode. When you say the word explode, it causes him to get up and try to have an outburst.
What you can't hear on the tape is another deputy in the corner of the courtroom.
I've been very fortunate. I've never had anybody super pissed off at me like that to cause that. So, remember, violence doesn't solve anything that words can't. Okay? Walk away. So if you're with your lady and you feel like you put your hands on her, don't. If you're at a bar and some guy's giving you shit, it's better to walk away. Because you never know what the guy's got in his pocket. You never know what's going to happen. You can hit your head and die. It's just... And never, don't always be deferential and polite and courteous in court. I've had many times in court where I've hated the other side. Fucking can't stand the other lawyer. But the more outrageous they get, the more calm I get. And the more calm I get, the more outrageous they look. And as you can see, this violence never helps anybody. Yeah, it's just one quick update or announcement. Like I said in the last episode, I will not be here in the month of August. I'll be on the road with my road warriors, whatever, going up to Alaska for the whole month of August. So we'll be sending some travel log footage, and we'll do some episodes on the road. We might recirculate some of the old episodes. Not sure exactly what we're going to do, but our content genius, make no mistake, has got everything in the palm of his hand. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal lawyers. Michael Rivers is our content genius, as always. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please, is that my God?
This is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. Today we're reacting to the closing arguments on both sides in the Depp versus Heard case. Now, I've been in trials that lasted a long time, and 6 weeks is a long time to be in trial. I mean, it just is. You get to know everybody around you, and you better start liking people because it could be a long 6 weeks. But closing arguments, are different than an opening statement. Opening statement, all you can really do in an opening statement is say the evidence will show. It's just kind of an introduction to what the case is about. You can't argue your case in an opening statement. All you can really do in your opening statement is basically introduce the jury to the case. Now, when it comes time for closing argument, though, this is where the rubber meets the road. This is where you can win a case based on your closing argument. And this is the time where you argue the case, and they only get so much time because the judge is timing this, and you really have to be strategic. And in this case, they have so much to draw from, so you have to be really strategic. So let's get into it. Camille starts it out.
2016. Ms. Heard walked into a courthouse in Los Angeles, California, to get a no-notice ex-parte restraining order against Mr. Depp, and in doing so, ruined his life by falsely telling the world that she was a survivor of domestic abuse at the hands of Mr. Depp.
So she's going right after her, by falsely telling the world, by getting a no-notice. What a no-notice is, it's an ex parte. So in order to get the restraining order, all you have to do is allege that there's some kind of abuse. Judges will sign it as if it's a leaf coming blowing in the window.
Today, on May 27th, 2022, exactly 6 years later, we ask you to give Mr. Depp his life back by telling the world that Mr. Depp is not the abuser Ms. Heard said he is, and hold Ms. Heard accountable for her lies. Now it's time for you, the jury, to come to a decision. You have been entrusted with a serious task. What is at stake in this trial is a man's good name. Even more than that, what is at stake at this trial is a man's life.
Now here's the thing. When you were advocating for your client, and I've actually teared up in closing arguments before. one U.S. attorney called me Crimea River. But here's the thing. First of all, I guarantee you, Camille, and the whole team is very attached to Johnny Depp. They believe in their cause. They know what they're doing. And so it becomes emotional, and it becomes, a mission.
The life that he lost when he was accused of a heinous crime, and the life he could live when he was finally vindicated. Exactly 6 years ago today, on May 27th, 2016, Ms. Heard walked into court and filed a false report of domestic abuse against her husband of 15 months, Johnny Depp. The scene was a setup. She tipped off the paparazzi so they would be waiting. They knew exactly where she would pause, which side of her face to photograph. And the photos captured what she wanted them to see, the image of a battered woman. What the paparazzi did not know is that the dark mark on her face mysteriously appeared 6 days after last seeing Mr. Depp. It was
So you probably wouldn't have that bruising 6 days later, and that's critical. And then all of a sudden you see the other photograph of her. I really like Camille's presence. She's to the point. She's not over the top, but she's kind of cold.
a lie. She knew it. Mr. Depp knew it. And the multiple witnesses you heard from who saw her that week of May 21st, 2016 also knew it.
When I say cold, I'm not saying that she's like off-putting, or I mean, when I say cold, I mean she's like a laser. She knows exactly what she's going to say. She knows how to say it, and she's very prepared.
But the world only saw what she wanted them to see. 2 years later, when promoting the biggest role of her career until this trial, Ms. Heard presented herself to the world as a public figure representing domestic abuse. The headline of the op-ed featured the term sexual violence, even though she had never before accused her ex-husband of such a heinous crime. Ms. Heard and her lawyers love to remind you of how the op-ed did not mention Mr. Depp by name. But Ms. Heard made sure that there would be no mistake about who she was referring to. She inserted 2 years ago, so the world would remember the photo of a battered woman, the mark on her face, standing outside the courthouse.
So that's an important point, because this isn't just about domestic violence or this or that. It is about defamation, and she has to get all the elements out.
And they would once again see Mr. Depp as the villain, this time in full swing of the Me Too movement. But what was happening behind closed doors was quite different from what Ms. Heard presented to the world. The exact opposite, in fact. There is an abuser in this courtroom, but it is not Mr. Depp. And there is a victim of domestic abuse in this courtroom, but it is not Ms. Heard. The evidence presented at this trial has shown that Ms. Heard is in fact the abuser, and Mr. Depp the abused. As you heard from Mr. Depp and multiple other witnesses that testified under oath at this trial, Mr. Depp experienced persistent verbal, physical, and emotional abuse by Ms. Heard during their relationship. You heard from Mr. Depp about how often Ms. Heard would berate him, insult him, and physically attack him.
So, and there's actual recordings and video to back up what she's saying and to back up Johnny Depp's claims. It is just remarkable that there isn't one single piece of audio or video that she has taken that corroborates him abusing her.
Including one of the most serious occasions when Ms. Heard threw a vodka bottle at Mr. Depp, severely injuring his finger, and then put a cigarette out on his face. You heard from Mr. Depp that this whole incident in Australia started because Ms. Heard was enraged that Mr. Depp wanted a post-nuptial agreement, and she wasn't in his will, just a month after getting married. You also heard from Tara Roberts.
Well, that would piss any woman off.
A manager at Mr. Depp's island who witnessed Ms. Heard telling Mr. Depp that he was washed up and would die fat and lonely. You also heard from Ms. Roberts that she witnessed Ms. Heard clawing and grabbing at Mr. Depp, grabbing his hair, trying to pull him back to her, and Mr. Depp had a visible injury to his nose on that occasion. Most importantly...
All right, I'm going to speak to the guys out there. You know, if you're with a woman that is toxic like this, actually, I'm going to speak to everybody. If you are with somebody that's that toxic, that's pulling this kind of crap, you need to just quietly leave them. And sometimes it's easier said than done. But you can't be constantly berated, constantly told you're a piece of shit. You can't be physically harmed. I mean, if you love somebody, you love them, and it shouldn't be that hard to get along. But sometimes people have personality problems, and those people, you just need to leave them in the dust.
You heard from Ms. Heard yourselves on multiple audio recordings admitting to being physically violent with Mr. Depp. What you didn't hear on a single recording you heard in this case, and there were many played by both parties, is Mr. Depp ever admitting to hitting, punching, or kicking Ms. Heard. You didn't hear it. It doesn't exist. It didn't happen. And despite the fact that Mr. Depp and Ms. Heard are heard discussing many of the alleged incidents you've heard about at this trial, like Australia and the Bahamas, you never heard Ms. Heard accuse Mr. Depp of sexual assault. Unlike Mr. Depp, who you heard admit to and own up to his past mistakes and his struggles, particularly with drugs and alcohol, Ms. Heard will not admit that she has ever done anything wrong. But she cannot deny what you heard on those recordings.
That's an interesting point because, you know, nobody's perfect, right? And if you have a situation where you don't admit anything, that any bad fact against you, no one's going to believe it. And that's what she's kind of getting at here.
As much as Ms. Heard and her lawyers have tried to make this case about Mr. Depp's language, it is Ms. Heard that repeatedly admits to violence. So let's talk about the giant lie at the heart of this case. Ms. Heard's claim that Mr. Depp is an abusive monster and that she is a public figure representing domestic abuse. She spun a story of shocking, overwhelming, brutal abuse. She came into this courtroom prepared to give the performance of her life, and she gave it. Ms. Heard's acting coach, Christina Sexton, testified that Ms. Heard has difficulty crying when she is acting. You saw it.
This is a great line. I love this.
Ms. Heard sobbing without tears, while spinning elaborate, exaggerated, fantastical accounts of abuse. And
My dog stepped on a bee. He really did. My dog stepped on a fucking bee. When you're sitting there crying and not a single tear comes out, you know, that's a tell. That is an absolute tell that she's acting on the stand. And not very well, I might add.
Everything going on in her mind almost a decade prior while enduring that abuse. It was a performance. What we have is a mountain of unproven allegations that are wild, over the top, and implausible. And you can't pick and choose which of these wild allegations to believe and which ones to disregard. You either believe all of it or none of it. Either Mr. Depp sexually assaulted Ms. Heard with a bottle in Australia, or Ms. Heard got up on that stand in front of all of you and made up that horrific tale of abuse.
First of all, that tale that she tells is absolutely horrific. And why he wouldn't have been brought up on criminal charges, that's sexual assault in the first degree. Ridiculous. And when Camille says you either believe all of it or none of it, there's a Latin phrase that they teach you in law school. It's called falso in uno, falso in omnibus, which means if you're lying about one thing, you're lying about everything. So you can disregard somebody's entire testimony by one lie. And that's kind of what she's talking about here.
Either she's a victim of truly horrific abuse, or she is a woman who is willing to say absolutely anything. But this case doesn't come down to whether you believe Ms. Heard or you believe Mr. Depp. This case comes down to whether you believe Ms. Heard or you believe Mr. Depp, Christy Dombrowski, Sean Bett, Malcolm Connolly, Travis McGivern, Starling Jenkins, Keenan Wyatt, Dr. Kipper, nurses Debbie Lloyd and Aaron Filati, Tara Roberts, Ben King, Kate James, Kate Moss, Dr. Colber, Morgan Knight, Morgan Tremaine, Officers Melissa Sines, Officers Tyler Haddon, Officer William Gatlin, and Beverly Leonard.
See what she did there? That was masterful. Remember what she did during the cross-examination of Amber Heard during her rebuttal? She lined up all those witnesses, and that's exactly what she's doing here in the closing argument. It just meshes, it just fits. So this isn't Depp versus Heard. This is Heard versus Depp, and then she lines them all up because all those witnesses corroborated Johnny Depp's version and discredited. They can't all be lying, can they?
What Ms. Heard testified to in this courtroom is the story of far too many women. But the overwhelming evidence and weight of that evidence shows that it's not her story. It's not Ms. Heard's story.
When she talks about the overwhelming weight of the evidence, in civil cases, so in a criminal case, the proof is beyond a reasonable doubt. It's the highest burden. That's what I'm used to. In a civil case, it's just preponderance of the evidence. So Johnny Depp only has to prove it's slightly more true than not true. And if he does that, he wins his defamation claim.
It was an act of profound cruelty, not just to Mr. Depp, but to true survivors of domestic abuse. For Ms. Heard to hold herself out as a public figure representing domestic abuse. It was false, it was defamatory, and it caused irreparable harm.
So here's the thing. Whether Johnny Depp wins this trial or not, public sentiment seems to have shifted in his favor. And to that end, he wins, even if he doesn't get a good verdict in this case.
And to talk more about that, I'm going to turn it over to my colleague and my friend, Mr. Chu.
As Ms. Vasquez said, you have now come to know the real Amber Heard. Scary. We also told you at the start of this trial that you were going to come to know the real Johnny Depp, not the many characters you've seen him play so wonderfully in the movies, but the man himself. We kept that promise. You've met the real Johnny Depp. Before Amber Heard, ladies and gentlemen, no woman ever before Amber Heard ever claimed that Mr. Depp raised a hand to her in his 58 years. And
that's kind of an important fact because you don't just all of a sudden start being a dick. You don't all of a sudden start just beating on somebody. I've seen this happen with guys who are wife beaters, and that's who they are, and they're very difficult people to represent, to be quite honest with you, because nothing is ever their fault. They're cheap, and she's always to blame. It's just ridiculous. So I like the point that he's making there.
And no other woman since Ms. Heard made that false claim back on May 27th, 2016, and repeated it in her December 2018 op-ed. Has any woman come forward since? This is Me Too without any Me Too. To the contrary, ladies and gentlemen, you heard Kate Moss 2 days ago testify.
Now, if you remember that Kate Moss testimony, that was completely unnecessary, a completely unforced error by Amber Heard. She created this image of Johnny Depp running to her rescue and saving her, the exact opposite. And had she not testified about that, Kate Moss wouldn't have been allowed to testify.
A woman who has never testified in any proceeding ever, a very private person, testified that Mr. Depp never abused her and that Ms. Heard lied to you. And she lied to you twice. Beyond the personal and emotional effects of Ms. Heard's lies, their impact on Mr. Depp and his family, the damage she inflicted on his reputation and career is undeniable. There's an old saying that a good reputation takes a lifetime to build, but only a second to destroy. Mr. Depp spent, in fact, a lifetime building his reputation as one of the greatest actors and movie stars of his generation, an iconic figure respected and liked throughout Hollywood and recognized and admired throughout the world. As you heard in this case, Amber Heard is not a true victim, and Mr. Depp certainly is not an abuser. Again, nobody has come out of the woodwork to say, Me Too. This is the unique and singular Me Too case where there's not a single Me Too. While Mr. Depp's name will be forever tarnished by these horrendous and false allegations, this case is about telling you his story and the truth about what really happened, which you've now heard. It is about restoring.
The other thing is, and it gets a little drawn out, but they have to go through damages. And if you look at the difference between Johnny Depp's damages and Amber Heard's damages, I think what she did is she just looked at his number and doubled it. I'm almost positive that's what she did, $100 million. And I don't think she proved any of her damages. So let's take a look at the closing argument for, or just some of the highlights of the closing argument for Amber Heard's team.
You don't leave Mr. Depp. And if you do, he will start a campaign of global humiliation against you. A smear campaign that lasts to this very day. He will do everything he can.
Now, maybe it's because I am more pro-Depp, because I just kind of like their team better. But I don't know, this guy's voice bugs me.
To destroy your life, to destroy your career. That is what they're saying, ladies and gentlemen. And that's what they're trying to get you, the jury, to be an accomplice to. But it's not surprising, because Mr. Depp cannot and will not take responsibility for his own actions. It's always someone else's fault. Does the First Amendment...
That's interesting, because it's exactly what I've said about Amber Heard.
Give Ms. Heard the right to write the words that she wrote in this article on December 18th, 2018.
So the First Amendment's an interesting argument here, because the First Amendment really protects speech, but not all speech. You can't yell fire in a crowded theater. But it protects you against government action. It doesn't protect you against private action. So it's a little bit misplaced, I think.
That's the question. And you cannot simultaneously protect and uphold the First Amendment and find in favor of Johnny Depp on this claim. You simply cannot. You have to decide, should someone be able to write an article like that in the United States of America without being sued successfully, without having to go through the hell that Ms. Heard has gone through? Think about every piece of evidence that you've heard over the last 6 weeks.
So his First Amendment argument is interesting, because it's I mean, that's what he comes out with. He doesn't come out with the allegations are true. I mean, which is really the ultimate defense to this, and which is what I would have come out of the block. I don't know why you would come out right away with the First Amendment argument. It seems weaker than you can't find for her because, or you can't find for him because it's true.
About his abuse, about their relationship. None of that is in the article. None of it. We all know that it would be a very different article if she had written about what she suffered, that she's told you about over the last 6 weeks. Because he knows the words are true, Mr. Depp says that the words now have a defamatory implication. He says the statements are the same as saying, Johnny Depp abused me. But just because he wants to make the article about himself doesn't mean it is.
She said it was about him. So he's contradicting the testimony of his own client.
He has to show you that any defamatory implication was designed and intended. Look at number 4. Designed and intended by Ms. Heard to convey the defamatory meaning that he suggests.
So one of the things you do in a closing argument is you can put up the elements, and that's what they've done here, is just put the elements of what needs to be proven.
Just because people might read the article and remember, oh yeah, Amber Heard used to be married to Johnny Depp, and she accused him of abuse, that doesn't mean that she designed and intended defamatory implications in writing about herself. And think about it. If Mr. Depp is right, then virtually any statement that anyone could ever make about their own life that implies anything, implies any involvement with any other person, could be defamatory. And
that's not true. I mean, you can't. These are highly, highly, highly visible people, and the words matter.
It's clearly not what the First Amendment intends. She didn't design and intend the words to be the equivalent of writing Johnny Depp abused me. And you don't have to take her words for it. You can take the words of Terrence Doherty of the ACLU. He said that the op-ed wasn't even Ms. Heard's idea. The ACLU wrote the first draft, and great care was taken in drafting the article so as not to make it about Mr. Depp or Ms. Heard's relationship with him.
Again, he's contradicting his own client.
That's the only evidence presented about Ms. Heard's motive, except her statements that was exactly what she wanted to do. She wanted to talk about her experiences after Johnny Depp. Ms. Heard didn't write the headline. She didn't approve the headline. She had nothing to do with it. She was not given notice of the headline. She testified, you saw her testify about the sexual assault that she experienced at the hands of Mr. Depp. You saw her testify about that they're calling her a liar. You saw her on the stand testify with your own mouth, with her own mouth, exactly what she went through for the first time in court, because people who have suffered that, they don't want to broadcast that to the world. They want to penalize Ms. Heard for not speaking about that earlier. That's ridiculous, and it's insulting, and it's just victim blaming at its most disgusting. The only reference to sexual assault in the article, and you can read the op-ed, is sexual assault that she said she had experienced by the time she was of college age, before Mr. Depp. So there is a reference to sexual violence in that article, but it's not by Mr. Depp. And Mr. Depp can't hold her liable for a headline she didn't write. It contains something that was not about him. And they want you to think that she republished the headline by tweeting out the link to the online version. So let's look at this. This is the tweet.
So this gets a little drawn out, but you sort of get the point. I mean, the difference between the two sides is stark, I think.
You can't give him anything. They didn't tell you that, but the court told you that. And that's a very, very important thing here. He told his story. He had his opportunities. He had his full opportunities to do all of that. And he came in here and lied to you and said he's here to get him.
The difference between Mr. Rattenburn and Elaine, she's speaking with a lot more passion. And not super big fan of hers, but she sounds more like a prosecutor.
Reputation back. It's just one of many lies in this case, but it's a really big one, because here we are, 6 weeks of your time, precious time, 6 weeks of this court's time, for what? For nothing. Only to go after Amber. That's psychological abuse. He's going after Amber for nothing, because he wants to put her through this again, the third time. So we're fighting back, and that's the counterclaim. She finally has said enough, enough. And we're asking you to finally hold this man responsible. He has never accepted responsibility.
See, that's actually, the way she's going about it is actually, that man, I think that's effective.
For anything in his life. Once again, the next day, Johnny apologizes to Amber. He says in 2 different text messages, that 772 and 773, he says my profound apologies in one of them, and my apologies are eternal in the other one. What is he apologizing for the next day on May 22nd if he didn't know that he did all of those things? She wasn't wearing any makeup. She was natural. She wasn't wearing a stitch of makeup. Every one of them says it. It's the exact same thing. Well, why would you say that? She's an actor. She's not going to go outside her house, without putting makeup on. And if she has bruises, why on earth, when she's been covering them up for 4 years, why on earth would she not put makeup on so that she would cover those up? Why on earth would she not want to cover up those bruises? It makes no sense. But you know what? You guys saw her here. You guys saw it.
So that is an interesting fact that she just brought up. And lo and behold, when TMZ's there at the courthouse, the only time they're displayed, she's not wearing makeup.
You saw Amber on the stand. There were days where she didn't wear eye makeup. A lot of people think that she's not wearing makeup when she doesn't have mascara and eyeliner on. She has different looks, and some of them are with eye makeup and some of them are without. And people misunderstand, especially people that aren't that good at makeup, and a lot of men, frankly, go, oh, then she probably doesn't have makeup. And that's where that mistake happens. But you heard her testimony, and you heard her makeup artist testimony saying she doesn't go out of her room without concealer and foundation. She knows how to put these things in.
But somehow she's at the courthouse. Look at my bruise from her bruise kit.
And you saw Defendant's Exhibit 155, and you'll have the actual thing in there. That's the type of palette she used, and she was very adept at telling you what colors she puts on for
her bruise kit.
Different days of bruises. This is a woman who for 4 years did everything she could to cover up anybody knowing anything about this abuse. Do you honestly think she's just going to walk around for the week with her bruises exposed? Of course she's not. If you do the math, Amber is entitled to at least 31.5. What does she take?
31.5. Well, you asked for 100, so now you're down to 31.5?
$7 million. What does she do with the $7 million? She gives it to charity, or she intends to give it to charity. Now, they make much ado about the pledge versus donation, but both the corporate designees for ACLU and for Children's Hospital said donation and pledge are interchangeable. These are pledges. The ACLU corporate designee said.
So next week, when it comes time for payroll, I'm just going to pledge to my employees their payroll. Because we just pledge it. It's the same thing as getting paid, right?
You typically do pledges because of the tax benefits, and that's what she said. She pledged it over a period of time because of the tax implications to it.
But she hasn't paid shit. I mean, I wouldn't even bring this up because she looks like it's just a losing argument.
To it, and because she was getting paid over the time. Now, she started to make these donations, and you'll see that the first one was on behalf of Mr. Depp's business manager, Mr. White, actually sent the letters with the $100,000 for each of those. That was the initial ones. He was trying to take credit for those, and in fact, both the ACLU and Children's Hospital got confused and gave the credit to Mr. Depp, not to Amber, for those. Then she made payments to both, and Elon Musk also made payments to...
She made shit. It's everybody else paying.
Both for $500,000 each, which she didn't count to her pledge, but they helped those organizations. At the end of the day, she's made $1 million in payments to them, but then she got sued here and hasn't been able to because she spent $6 million in attorney's fees. That is unrefuted. She still intends to.
She just said she spent $6 million in attorney's fees. $6 million.
Pay those pledges, honor those pledges, and she said that throughout.
See the look on Camille's face when she said $6 million?
Throughout, and I elicited from both the ACLU and from Children's Hospital, they haven't expired. She can pay them whenever she wants to, and she fully intends to, but she has to get out from under this first. They started to get Amber fired from Aquaman 2. They have continued to this day. They have followed her everywhere.
So we don't need to watch any more of that. Here's the thing. The difference in caliber lawyers is just stark. It really is stark. the difference in approach to the case is stark. Amber's not going to get squat. She'll be denied her counterclaim. I think Johnny Depp will win this case, but I don't know for sure. You never know what a jury's going to focus on. You never know what they're going to hang their hat on. I just had a case where the jury could not decide after 3 days of deliberation, and it's a tough thing trying a case. It really is, but it's fun. It's so rewarding, and at the end of the day, when they got done, and I guarantee you, those lawyers know Johnny Depp better than anybody else. And it looks like they gelled as a team. It looks like he gelled with his lawyers. So now the jury's going to deliberate. And they've got a lot. They sat for 6 or 7 weeks in the trial. And it'll be interesting to see what happens. So we'll continue to follow it. You guys follow us. Subscribe. Like. Comment. I read the comments. And follow us on Instagram. Follow us on Twitter. Sign up for Patreon. Spread the word. We'll see you next time here on Criminal Lawyer Reacts. Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, coming to you with our content genius behind the camera, Michael Rivers. Today we're reacting to Idaho murder suspect Bryan Kohberger. He entered an appearance in court just recently where they indicted him on murder one, and we'll talk about that and what the process is. But before we get to that, guess what? This is brought to you by eSign.com. eSign.com is a very effective way to remotely do business. Let's say you're in custody and your family needs to take care of some business because you're Bryan Kohberger and you just don't have the wherewithal to be anywhere to sign something in person. So what you do is you just have your father or whoever you want to assign power of attorney email the jail staff there, download the app, you get 3 free signatures a month, and the jail staff will come in, hey, Bryan, come on down to the pod. They have him e-sign a document, and now you got power of attorney. And it's easy to remotely do business with eSign.com. Because if it's not eSign, no one signs. Okay, so here's the deal. He was scheduled, when I say he, I mean Bryan Kohberger. Now let's just recap it a little bit. Remember, he's the one that killed those 4 college students in Idaho? Brutally killed them and left his DNA there, and they figured out his car was there. Bryan Kohberger was supposed to be in court to have a preliminary hearing. What is a preliminary hearing? A preliminary hearing is a hearing that, Minnesota doesn't have that, but a lot of states have preliminary hearings where the state has to establish probable cause. It's a very low standard, but they have to put on some evidence. They don't have to put on all the evidence, but they have to put some evidence on. And a lot of times it's just pro forma. It's a way for the defense to kind of get access to some discovery early on, and you get a chance to question witnesses. Well, what they did instead, they were scheduled for a preliminary hearing. They indicted him on murder one instead. In other words, they took their case to the grand jury. It's between 18 and 23 people. It's a secret process. And the grand jury decides whether there's probable cause. Probable cause just means it's slightly more true than not true. So let's take a look at the indictment. So count 1 is burglary. And burglary is defined as entering a dwelling with the intention to commit a crime therein. And in this case, the crime is murder. So it says, count 1, burglary, that the defendant Bryan Kohberger, on or about November 13th, 2022, in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, Idaho, with the intent to commit the felony crime of murder. Well, the murder is really the crime here, but burglary is like, who cares when you're looking at this stuff. Then they indicted him on count 2, murder in the first degree. Count 3, murder in the first degree. Count 4, murder in the first degree. Count 5, murder in the first degree. And each one basically represents each victim. So he's got 4 counts of murder in the first degree, and then 1 count of burglary. So what happens when you get an indictment? Well, you have to have an initial appearance, and that's where you enter your guilty or not guilty phase, or plea. And so when in this case they didn't enter a guilty, and they did what they call a silent plea. That means you don't take a position on it one way or the other. So when you do that, you're not saying you're guilty, you're not saying you're not guilty, and the judge has to enter a not guilty. Let's just take a look and see what happened here in court.
But you're not required to testify because you also have the right of silence. That right is protected under the Idaho and federal constitutions. So
you have the Fifth Amendment right against self-incrimination. You all know that. And so what he's saying is while you're in court here, you can't be compelled to testify.
You remain silent throughout these court proceedings, and that can't be held against you in any way. What you do need to remember, though, is that anything you do say, other than to your lawyers, could be used against you in a later court proceeding. You understand that?
Yes, I do.
Okay, thank you.
When you're in court, they go overboard to try to make sure that a defendant's rights are observed. And there's a reason behind that. People sometimes get pissed off, especially if they're victims of a crime, that, they don't, consider the victims, blah, blah, blah. The problem is if they're not careful, then we have to come back and do it all over again. And that can be traumatizing for any victims.
Do you have a copy of the indictment in front of you?
Yes.
Okay, thank you. And you see in the heading your name there. Is that your correctly spelled complete name?
Yes, it is.
So they're going through the indictment, and it seems tedious and kind of almost self-explanatory, but there's a reason that there's a redundancy in the process.
All right, I'm going to read you the charges on the indictment, starting with count 1, burglary. That is a felony under Idaho Code Section 18-1401 and 1403.
So this is the part of the arraignment where the judge can read the charges, but you can also waive it. Usually you can see this. Your Honor, we enter not guilty plea, waive any further reading of the complaint, ask the matter be set on for a pre-trial hearing. That's usually what happens.
This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder. Count 2, murder in the first degree. That was a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died.
When you have the indictment, in other words, when a probable cause finding has been made by a jury or a grand jury, you don't get the opportunity then for a preliminary hearing. So that's one of the strategic reasons why they did this. But in some states, like Minnesota, and other states, in order to be charged with murder 1, you have to be indicted by a grand jury.
Count 3, murder in the first degree, a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Kayla Gonzalez, a human...
Now, if you remember, and I guess we don't really know yet exactly what his motives were, but we do know that he had an encounter with, when I say an encounter, a meeting or chance meeting with somebody at a coffee shop that may have been part of this group. But we really don't know what his ultimate motive was. We do know that he was a PhD candidate in a criminology type of curriculum, and he thought he was smarter than everybody else. And he was also on the hook. In other words, he might have been on the verge of getting kicked out.
Being by stabbing Kayla Gonzalez, from which she died. Count 4, murder in the first degree, That's a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. Alleging that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully.
You hear the whimpering in the back of the courtroom? That is, the family. I mean, it's got to be so difficult for them to sit through this and hear their child's name read off in open court because they were brutally murdered for absolutely no fucking reason whatsoever.
Deliberately, with premeditation and with malice aforethought, kill and murder Zaina Kernodal. Excuse me. This is hard. I'm sorry. Zaina Kernodal, a human being, by stabbing Zaina Kernodal, from which she died. Count 5, murder in the first degree. This is a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing Ethan Chapin, from which he died. This is signed on May 16, 2023, by the presiding grand jury. So now I'm going to go to the maximum penalties of each charge, starting with count 1.
So, and the reason that they do this is because you have a constitutional right to know what you're being charged with and what the possible penalties are.
Burglary, minimum 1 year, up to 10 years in imprisonment, fine of up to $50,000 or both fine and imprisonment, restitution for the victim's economic losses resulting from the crime. For counts 2, 3, 4, and 5, murder in the first degree, maximum penalties, life in prison, or the death penalty. Fine of up to $50,000 for both fine and life in prison or the death penalty. Restitution for the victim's economic losses resulting from the crime. Also, additional fine of up to $5,000 to be paid directly to the victim's families. If you are found guilty or plead guilty on each charge, and the maximum sentences are imposed consecutively, that means one right after the other, you could be facing 10 years in prison, followed by 4 consecutive life sentences or death penalties.
Anytime you have more than one victim, a court typically sentences each victim consecutively because they have to be accounted for according to the law. So even though it might be one single course of conduct, if you have 4 victims who are specifically assaulted, murdered, or whatever, they have to be taken into account, and judges typically sentence them consecutively versus concurrently. Consecutive means one after the other. Concurrently means you do them both at the same time.
Fines of up to $200,000 and $20,000 to be paid directly to the families with any restitution resulting from the crimes. Okay. Mr. Koberger, do you understand the charge in count 1, burglary?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 2, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 3, murder in the...
Meanwhile, you're sitting next to a guy who just murdered 4 people. 4 people. Hard. That's just hard to wrap your head around. So if you're... And there appears to be no real motive. Now, keep in mind, he's presumed innocent, okay? And we don't have to do that here because, well, what are we doing? We're waxing philosophic. We're not in a court of law. So just because you're on my program and I'm doing this kind of crap, or our program, because I have to take into account our content genius, it doesn't mean that you get the presumption of innocence. However, this is a circumstantial case, and they have some really, really excellent police work that they did in this case, but we'll see what happens.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 5, murder in the first degree? Do you understand the maximum penalty?
Yes.
Okay, Ms. Taylor, is Mr. Koberger prepared to plead to these charges?
Your Honor, we will be standing silent.
Okay, because
Now, that's not super common. I mean, maybe it's super common in Idaho, but when you say we're standing silent, well, the judge is forced to enter your not guilty plea. So, but I don't know what the benefit of that is. Maybe it's your client, doesn't want to speak, or you just don't want to be out there as saying someone's not guilty when you are, looking at such a serious case. I just don't know. I've been doing this 25 years, and I've never entered a silent plea.
Mr. Koberger is standing silent. I'm going to enter not guilty pleas on each charge. Counts 1, 2, 3, 4, and 5. Now, at this juncture, the state has 60 days to give notice of intention to seek the death penalty. And Mr. Koberger has a constitutional and statutory right to a speedy trial.
So you just heard the judge talk about capital murder and what they needed to show, or not, that the state has 60 days to give notice. Remember we saw that in Mellie, that they tried to get around the notice requirement and say that the state didn't give him notice to try to get death penalty off the table. In this case, the state's got 60 days to give notice. And then it usually has to be an aggravating factor. And believe me, in this case, there are aggravating factors. At the time the murder was committed, the defendant also committed another murder. So you've got 4 murders together. The defendant knowingly created a risk of death to many persons. That's what we have here. The murder was committed for money. No, we don't have that. The murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. Probably, maybe not. The murder or circumstances surrounding the commission, the defendant exhibit utter disregard for human life. Definitely, that would be the case. The murder was committed in the perpetration or attempted to perpetrate arson, rape, robbery, blah, blah, blah. There are other crimes. So anyway, so it just suffice it to say there's got to be some aggravating circumstances. And the fact that you have 4 people killed are probably the most aggravating thing you could see. Idaho recently passed a law reinstating the firing squad, so death by firing squad. So that'll go into play July 1st. Unknown whether that would apply in this case since the crime was committed prior to that. Whether it's lethal injection or firing squad doesn't really matter at that point, right? What's going to happen now, this will be the discovery phase. They'll be getting more and more discovery from the cops and from the prosecutor. And there's a couple different things that go on. Number one, they're going to get that death penalty notice. When they get the discovery, you have to determine whether or not there's any violation of constitutional rights. In other words, if they took a statement without Miranda, if they searched the house without a warrant, if they obtain any of the evidence in violation of constitutional rights, then you file a motion as a defense lawyer to suppress. And now this is wide open to the public, so it's going to be on TV and it's going to be all over the place. So we'll continue to follow it. This is our reaction to Brian Koberger getting indicted on murder 1, 4 counts of murder 1 count of burglary. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers with our content genius, Michael Rivers. We'll see you next time. Make sure you sign up for Patreon, follow us on Instagram, follow us on Twitter, and subscribe. We'll see you next time on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away.
23-hour lockdown, police is at my god.
Completely unjustified. All this destruction over what? Over fucking nothing. Over nothing. Literally Nothing. Just a little bit of noise.
Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode, or not so fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your board-certified criminal defense lawyer, where we tackle real issues. You learn what the elements of certain crimes are and defenses, and we break down cases. And I am coming to you with my pearl handle pistol cufflinks, so graciously gifted to me by our content genius, Michael Rivers. And today we're reacting to this Brooklyn shooting that happened in an apartment building. We'll talk a little bit more about all the intricacies and gun violence in general, and just some other kind of great topics that are relevant to this case. But before we get to that, this is brought to you by eSign.com. eSign.com, a very effective way to remotely do business. You know, I've had people contact me on the channel, say they've used eSign. If you use eSign, just download the app. You get 3 free signatures a month, and you can use it for just about anything. For example, my grandma, you know, she's actually doing a geriatric rap circuit. It's a new thing that's coming up, and she just signed a record deal, but she's got a warrant because, she's not that clean, but she's from the streets, and so she signed a record deal, and from the comfort of her own Cheeto-stained underwear basement. So when you need a deal done fast, you go to eSign.com. eSign.com. I use it all the time. You know, it's an effective way to remotely do business. Because if it's not eSign, no one signs. Now, let's get on to this. Now, when you have a dispute with somebody, you can't bring a gun to a fist fight, generally speaking. Guns, first of all, we have too many guns in this country, honestly. We have too many people. Let me put it this way. We have too many people using guns in an inappropriate way, in a violent way. Solving problems with guns almost never works. You know, in that Maine shooting, the cops were there within minutes, and within like a minute and 18 seconds, that guy was able to fire off how many rounds, and he was able to kill 18 people in like a very short period of time. Apparently, in this particular case, dispute. And we're going to have to pixelate some of this, because otherwise we're going to get, it'll be a strike. I don't know how they do that kind of stuff. The content genius knows all. I mean, apparently this is a dispute about noise. Fucking noise. I'd put up with a little bit of noise so that I don't get shot. Or I'd put up a little bit of noise to avoid a conflict. But let's watch this, and then there's a press conference, and we'll talk about all this destruction. All this destruction over what? Over fucking nothing. Over nothing. Literally nothing. Just a little bit of noise. I'm gonna play it all the way through first, and then I'll play it a second time, and then we'll break it down. Now, I don't know what time of day this is, but he didn't have a shirt on. And somebody's upset with somebody over something. And there's no audio to this, unfortunately. So, I think that's a father and son there. You see him kind of hold a scissors to him. That's how fast somebody can die at the hands of a gun. So let's break this down a little bit more. So He's got no shirt on, no socks on, just a pair of shorts. Probably either late night or early morning. Now that's not a little guy. Yep, you see him adjusting the gun in his waistband. So the wife comes out. Just a nice lady, whatever. Son comes out. At this point, there's no violence going on. Just words between two parties. Now, we don't know what is said in terms of like whether he says I've got a gun or anything like that. But here comes Dad with a pair of scissors. Now, right there, Dad's holding a pair of scissors up to the guy's face. Now, scissors can be considered a dangerous weapon because if you could stab somebody and cut him and kill him. So at this point, would he be justified in pulling out his firearm? Probably. But you do have a duty to retreat. You just do. In some states you don't. But even if you don't retreat, you still have a duty to be reasonable under the circumstances. You can see that he's holding the scissors in kind of a threatening manner, and he's not a little guy. The wife's trying to pull him away. Now, listen to your wife. Now he's going for his gun. So there's a break in the action. Wife pulls him away, and there's a break. So he's not really being threatened at this point with the weapon like he had been earlier. Where now he pulls out the weapon, the firearm, and his back is to him. And he's starting to walk back to his apartment. That's a problem. That's a real problem for the shooter. So he shoots him. And then he shoots the son several times. Several times. Son's posing no threat to him whatsoever. Certainly not a lethal threat. Then he goes over. And you can see he shoots one last time into the father. And then he calmly goes back to his apartment or wherever he's going. That last shot, in all likelihood he wasn't dead yet. That would be premeditated murder because there's only one reason to do that. And all the number of shots that he put into the son, completely unjustified. This whole thing is unjustified. And this is what kills me, pardon the pun, but this is what kills me about solving problems. This whole concealed carry thing, I think, gives guys, their balls are just too fucking big at that point, because now I'm tough guy. Now I can take on anybody, Where's the check? Where is the check? When we had the George Floyd riots here, I had my firearm out, and we had people going up and down our street and lighting garbage cans on fire. And all of a sudden, I see some guy come out of my neighbor's yard, and it was a neighbor from across the street. Some kids had stolen some stuff, and I pulled my gun on him. And I was shocked at how easy that was. And he was not somebody that I had any problem with, that I didn't. And oh, it's you. Okay, sorry about that. And it was total mistake. When you get amped up, when you get really amped up, the firearm is not the answer. Walking away is always to live another day, to fight another day, to do something else. So let's see what happened to Mr. Shooter Guy.
Chief Patrol John Shell. Approximately 7:10 this morning on Bay 44th Street between Highway Avenue and Bath Avenue, Bath Beach section of Brooklyn. Uniformed police officers from 60 Precinct traveling down Bay 44th Street, utilizing the technology of the license plate reader. At this time, the license plate reader captured a plate on a black car, indicating that the car, and we now know the occupant of our car, were wanted for a double horrific homicide in the 6-7 precinct on Sunday, October 29th. The officers rounded the block.
So when a cop comes up behind you, they've got these license plate readers that just boop, and all of a sudden it goes right, does an NCIC check, and it can run a check on you, in like seconds. It's pretty good technology. And this guy was obviously on the street. They knew who he was, and wanted for a double homicide.
To verify the plate, and came up on the car that was parked. As they exited their police car, they walked up to the car. The male jumped out of the car with a knife in his hand and took off running. The officers pursued this male down to Bay 44th and Harway, were able to isolate and contain this male with the knife still in his hand. The officers called for backup. Members of the 6-0 Police Patrol came and were able to isolate and contain the subject on the corner. For approximately 15 minutes, they had a dialogue, doing everything they could to have the male drop the knife. At the end of this, the male, for some unknown reason, in a full sprint, charged the officers.
The amount of time it takes to close the gap, for lack of a better word, and use a knife is staggeringly low. Just like within a couple seconds. You can get like 21 feet within a couple seconds. Cops are not going to fuck around with that. Bye-bye. You know, they're gonna put bullets right in through you, and they're going to shoot for center mass. What does that mean? That means right here. Over what? What was this over?
Our officers were forced to defend themselves, to stop the threat, and discharge their firearm, striking the subject 4 times. 3 times in the chest, 1 time in the right leg. He was removed to a local hospital. He succumbed to his injuries shortly thereafter.
So 3 people dead. 3 people dead for and 1 grieving mother/wife. For what? For a noise complaint? And maybe it had been a long-standing battle between them. So the fuck what? If it's that bad, move. You know, I mean, think about all the things you could be doing on that day. I could be getting laid. I could be having a glass of scotch. I could be going for a nice walk around the park. No, I think I'd rather shoot somebody and then go on the run and then get shot myself. You know, and I'm really talking right now to a lot of young guys, because a lot of young guys, you know, they see the rappers, they see the, you know, the gun violence, and I'm all for firearms in terms of home protection, hunting, you know, that kind of. I think we have a, you know, Second Amendment right, and our Supreme Court has gone kind of the other way in terms of regulation. You know, that less regulation is better, and it is what it is. And I'm not even talking Second Amendment. I'm just talking practicality. You know, you carry a gun, you want to use it. You carry a gun, you think you're a tough guy. You carry a gun, you know, it's a big problem. I mean, look at what's going on in a lot of our big cities. So let's analyze what this guy did in terms of self-defense. Any use of force has to be proportional, but it has to be justified. So he has to have a reasonable fear of death or great bodily harm. And with the introduction of those scissors, that kind of is there. But once there's a break in the action, you know, he has a duty to retreat. In New York, you have a duty to retreat. You just do. If you don't avail yourself of that, but where it's reasonable. And so, could he have just turned around and walked away? Nobody was preventing him from doing that. Was the father justified in putting some scissors up to the guy's face? Probably not, because at that point there was no introduction of any weapons. We don't know exactly what they were saying amongst themselves. I'll shoot you. I'll shoot. I mean, he could have been saying that. And if he was saying that, does the dad have a duty to retreat? Not really. There's a thing called the castle doctrine. You don't have a duty to retreat in your own home, but they're not really in their own home. They're in a common area in the hallway. And the duty to retreat is only a duty as long as it's reasonable to do so. If somebody's holding a gun at you, would you turn around and just run away? Is that what a cop would do? I mean, would you put your back to somebody who's got a gun to you? You wouldn't. I mean, and so would you be justified in an immediate reaction? Absolutely. I've won cases on that grounds, and I'd say to the jury, I said, now, would it be reasonable for him to turn around at this point while this guy has a gun in his back? What do you think a cop would do at that moment? Whatever a police officer would do, that's the same thing that my client should do, because the law of self-defense applies the same to a police officer as it does to an individual, and it does. You know, if the cop does something that's unreasonable, if it's excessive force, it's not allowed. So in this scenario here, That guy was not justified, in my opinion, in pulling the gun. Not only that, when he fires, the father was walking away. The wife was pulling him away, and there was a distance between them. Totally unjustified. Then the son, I don't know what the son was thinking or what he was doing, but he wasn't really posing a threat of great bodily harm to the shooter. And he pop, empties that fucking gun right into him. And that's ridiculous. You know, and then he goes and gives a finishing shot to the father. That certainly wasn't justified. That's murder one. So there's absolutely, and he probably knew the jig was up, and he probably wanted it to die. And that's why he did what he did with the cops. Were the cops justified? 100% yes. Somebody's running at you with a knife, you are absolutely justified in taking them out. You just are. That's what the law is. It all comes down to proportionality and reasonableness of your actions. You know, what would a reasonable person do under some similar circumstances? I had a case one time where my client went to go collect $1,000 from another guy, drug money, and my client had a gun on him, and so did the other guy. And the other guy pulls his gun, and because he thought my client was disrespecting him, and my guy shot at him 8 times. I don't think he hit him 8 times, but he shot at him 8 times, and he died right there on the scene. And the jury came back and acquitted my client in about a half an hour because think about the gun with gun, like force. Now, had the guy just had a rubber band and my guy had a gun, he wouldn't have won because it's not lethal force. I implore you all to take these concepts into your head. Because, you know, they teach some of this stuff in, you know, gun safety classes. Oh, and here's the other thing. With self-defense, once you're able to get the instruction on self-defense on a homicide case, it's up to the prosecutor to prove that you did not act in self-defense. They've got to disprove the elements of self-defense, or one element at least. But, you know, they do teach this stuff in gun safety class, and I think it's so rudimentary, and it gives people a false sense of security. Would you rather be judged by 12 or carried by 6? I hate to see this. What a loss. What a loss. A young man and his father, and another young, he was not so young, I guess, but, and the other guy died. You know, you take rats and you put rats into a small confined area, they get agitated. You know, and that's what I think kind of New York is kind of turning out to be. It's a lot of people in a small area. And, you know, you've got your little space and you kind of infringe on my fucking rights, you know, fuck you, turn your fucking stereo down. Why do you have to get so harsh? Why don't you just bring him an apple pie and say, hey, would you mind turning it down? I'll give you this apple pie if you turn your stereo down. I mean, what would be wrong with that? I suppose pumpkin pie, because we're getting close to Thanksgiving, but I mean, what would be wrong with that? What would be wrong with giving him a flower instead of a bullet? And I'm sounding Pollyannish, I guess, a little bit, but I don't want to see anybody die. I don't like to see young people make bad decisions with firearms. And this guy made a bad decision with a firearm. He altered a lot of lives that day. He altered the cops' lives that had to shoot him. He altered the wife and the mother that was involved here. He ended the life of 2 men. Senseless over a fucking noise complaint. You know, I'm going to give you guys some homework. All right, I'm going to give you some homework. I want you, for the next couple days, you see somebody that maybe you like, maybe you don't like, try to make them smile. And see how that makes you feel when you try to make somebody smile. This doesn't make you smile. I'm really passionate about this. I really want everybody to really think hard about how you treat each other. You know, we're in a very divisive culture these days, but there's so many good people out there. So many good people out there. And I think that's you and me, and let's make everybody else solid and happy. Make somebody smile. Fuck, that pays dividends tenfold. All right, enough preaching for today. So make sure you subscribe, follow us on Instagram, follow us on Twitter, and sign up for Patreon. We'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away.
23-hour lockdown, police is at my god.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer with our content genius, Michael Rivers, at the helm. Today we are reacting to Charleston White calling CPS. And this episode, like all of our episodes, are brought to you by eSign.com. eSign.com, a very effective way to remotely do business. Let's say you are Charleston White and you're sitting there in your mother's basement with your Cheeto-stained underwear, and you are going to take this little kid's video and you're going to put it all over the place because you think you're going to make some money on it. Well, you got to buy a new boat, so you go to eSign.com, you download the app, you get 3 free signatures a month, and now because you put this little kid's video all over the place, you have to sign a deal. eSign.com is a very effective way to remotely do business. I use it all the time in my practice when somebody's out of town or can't make it to the office. Or if you want to execute something quickly, it's so much easier to go to eSign.com, and whether it's a power of attorney, bill of sale, rental agreement, any kind of agreement that requires, or anything that requires a signature, you can go to eSign.com. Now, here's the deal. Charleston White is not one of my favorite people on the planet because what don't I like? I don't like snitches. Snitches get stitches and sometimes wind up in ditches. And I'm not saying that's going to happen with this guy at all. But if he's really Mr. Do-Gooder, you know, why not call the people who are involved? Why not do something other than posting the call online? So let's take a look and see what he has to do.
Would you like to make a report today?
Yes, ma'am. I only have rapper names and street names, but I'm sure they're easy to find.
I only have rappers' names and street names. You know who he's calling? He's calling CPS, Child and Protective Services.
Yes, ma'am. I want to make a report of child neglect and child endangerment.
I don't know why this does this.
Okay, so before we get into...
So here's the thing. People call child protection. A lot of times they use it as weapons. You know, you see it all the time when, you know, in a custody dispute and whatever. And so I don't suspect that Mr. White has any real connection to this case whatsoever. He just sees a video and decides, well, I'm not going to investigate this. I don't have any firsthand knowledge of anything, but I'm going to cause this family some fucking trouble by calling CPS.
Sometimes I do need to collect some basic information on everyone involved.
Yes, ma'am.
Also, I want to let you know that your identity as the referring is confidential by state law.
Oh, no, I don't want mine to be confidential.
Oh, I want mine to be confidential. Give me a break. Of course you don't, because you're putting this out on Twitter. You know, you are making money off this. I'm making money off of a child suffering. You know, I would never put a little kid in the forefront.
I want mine to be identified. I want them to know I did it because I work with children, and it's an obligation to report something when you think children are in danger.
He is not. I doubt that he's a mandated reporter, and maybe he is if he runs a foundation or anything like that. And I'll be the first to admit that I don't know a ton about Mr. White, but I do think that putting this out there like this, I know he probably thinks, you know, this is my street cred, this is me getting my snitch on, but it is what it is.
Okay, what's your name?
Charleston White.
CHARLESTON
Yes, ma'am, just like Charleston, South Carolina.
Okay, and how do you know the child as a child?
I don't. I got a video that was sent to me that was made by this child online.
He doesn't know anything about what's going on. All he knows is he got a video sent to him.
There's videos of this child in the clubs at night with convicts, thugs around drugs and guns. And the kid's name is Lil King. He's a popular little rapper. So I have a video that I can send that you guys really can pull up on YouTube called Lil King Goes In on Charleston White. So just
Lil King Goes In on Charleston White. We'll watch that in a second.
Some of the things that he was saying in his video with the adults around him and then the other videos that surfaces.
And here's the thing. For a little kid to swear and do some of the things that Little King does in his video is not putting a child in danger. And there's a big difference between you not liking somebody. This looks more like retaliation than anything else.
Being in clubs, were almost every rap event that these guys have been at, they've had shootings.
Okay, give me just a moment here.
Yes, ma'am.
Hey, Mr. White, are you familiar with our email notification process?
No.
And here's the thing. How smart is it for him to snitch on people who, if everything they do is revolve around guns and shootings, and you're snitching on people who are not strangers to guns and not afraid to use them?
I'm not. Could you explain it to me?
Sure. So if you provide us an email address at the end of the report, we'll send you a link to the website, our website, where you can go to track your referral, and it'll let you know.
This is just 100% phony. It is just absolute, just for public consumption. It's not real because he doesn't have a. You think they're really going to follow up on a Little King rapper?
We prosecute before you to be involved.
Okay. Yes, ma'am.
All right. And what's that email address?
Swear to God, you're gonna get script food. I'm about molested. You gotta be gay.
So this is Little King, and Little King is all he's too. I don't even know how old is Little King. So watch this. This is just so insane.
Can't get caught in Texas. You're scripting him. It ain't nothing to talk about. You getting script off the rip.
I think that means that he's going to get killed or something like that.
I swear to God, you get script. Everybody.
Try not to.
They're gonna
I'm not touching.
be somewhere 6 feet under. Currently playing, thinking this is a joke. This shit ain't no joke.
Come on.
Fool, that man ain't playing with me, fool. We catch that man, fool. We gonna strip his ass. This over my grandma's head.
Who, where?
Now, I don't know how old he is. I bet he's not much more than 10, 12 years old, if that. And he's going to script his ass. I hope that, there would be somebody that obviously, but this whole online thing that I've been talking about, beefing online. And I don't think that Mr. White is doing anybody a service by putting this call to CPS, which is just absolutely nothing but bait for an online dispute. Why not take your platform, because you're such a decent and loving person who loves children, and instead of doing some fake call to CPS and putting it online to let them know that you're this whatever, why not try to impart wisdom? Why don't you tell them to build? Why don't you try to impart some wisdom with some positivity?
Flabby Billy, Larry Home built ass nigga. Larry Home built ass nigga. Wide hips, big thigh ass nigga. Coke bottle shape ass nigga, rapping ass nigga. Yeah, listen.
I think I can get behind that message, don't you think? I mean, can't you feel the positivity exuding out of Mr. White?
Type of nigga I be talking about. Finesse, Ness. You the kind of nigga I be talking about. Nigga, rock my ass nigga, pull them veneers.
Using the word fella over and over again is just, in this context, it's just beefing. It's absolute beefing, and this beefing online. Why can't, if you're supposed to be this pillar of your community, this seeker of truth, this purveyor of positive messages about children, about this and that.
You go back to rock my ass, nigga. Baby, that nigga look like.
Why not tell him in more positive terms on how to be? Because we point out the crimes that people are doing in videos all the time, and I don't do it as a judgment. When I do it, it's like, watch out, guys, because this is what you're looking at. And when you're dealing with child protection and you get child protection involved, that can really mess up your program quite a bit. When you have child protection involved in your life, and they all of a sudden dictate You know, they can get in your life in a number of different ways. They find drugs at the house. They find guns at the house. They find an unsafe condition. They find a systemic problem with either drugs or whatever. And they can wreak havoc on your life. But to play around with it like this and to put a beef together just for your own credibility as just something that is, you know, just an online daily business lacks foresight. He's his father of Lil King, right? Or Finesse, whatever his name is. And now he's criticizing the kid's father online hard. And when you're doing that, are you helping the kid out? Are you really helping that child? I just felt the need to speak out against snitches who are just doing this not for anybody's good. It's doing it for his own online bullshit. So this has just been my take on a fake call to CPS, and that's really what it was. I mean, he didn't have anybody's name. He didn't have anybody's address. He doesn't have any specific things except for one video clip that somebody sent him. Give me a break. And then he puts it all online, like, I am the savior of children. And then he goes on to criticize the kid's dad hard. And what do you think the kid's going to do? You know, I mean, is the kid being raised in an ideal environment? I don't know. It's not for me to judge. But he's going to get online and just continue this bullshit. And this is how people wind up getting killed today. You know, and so why not create a message of peace and love and harmony? Why don't you say, look, you know, you need help, you know, learning how to raise your children? We'll help you with parenting classes. We'll help you do this. We'll help you do that. Build a relationship instead of being Mr. Finger pointing. So I'm not a big beefer. In fact, I hate beefs with anybody. I don't like, but I don't like it when other people do it too, because this is just so ridiculously nonsensical. So, Mr. White, if you're watching, I'm sure, you know, I have 2 children. You gonna come after my children? I don't think so. So, I'm Bruce Rivers, board certified criminal defense lawyer. Stay off the beef. Start building. Be positive. Mr. White, be positive. Don't be tearing people down. Build people up. So we'll see you next time here in Criminal Lawyer Reacts. I'm Bruce Rivers, as I said, board certified criminal defense lawyer. We'll see you next time here on Criminal Lawyer Reacts. Subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon. We'll see you next time. And Mr. White, give me a call. Let's do a show together.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away.
23-hour lockdown, please, is that my God?